Pretty song from the Maccabees, Keshachalev Boche. We're doing a cappella music because we're in the 3 weeks, and tomorrow is Rosh Chodesh Av when we get into the 9 days which precede Tisha B'Av, and then we won't have music at all for those 9 days during the opening of the show. How's everybody doing? Great to be with you. Let's light up the darkness. Happy to report that my COVID, I took that positive test on Tuesday, but thank God the symptoms have remained really mild. And the initial thing that caused me to take the test, that I felt like I lost my sense of taste and smell, has returned. Thank God. I would say, not quite 100%, but I could definitely taste my food and smell various spices. So I'm just so thankful. Who's with us on a Thursday evening? Paul in Chicago, Shandor in the Bronx, Yehud in South Carolina, John in Maine, Renee in Indiana, Sharon in New Jersey, James in Indianapolis, Ira in South Carolina, Tracy says shalom, Marion in Glendale, James in South Carolina, Midge in North Carolina, Paul in the Great Northwest, Lucy in Minnesota, Bella in Florida, Melissa in Great Neck Guy in Ohio, Bart in Connecticut, Renee says Baruch Hashem. Welcome, everybody. We are on page 22 here in Tractate Kesubos, the 15th volume of the Talmud. These are the laws of the marriage contract, but because it's the law of a contract established at the beginning of marriage, which, when is it going to come into play? When that marriage ends, often many years later. And so very much there's laws of testimony, laws of witnesses, laws of credibility that come into play. And we've already seen that the Mishna number 3 that we've been examining was really all about evidentiary laws, who to believe, which witnesses are deemed credible, how many witnesses have to come forward, can a judge act as a witness? We continue that discussion here in chapter 2, Mishnah number 3 of Tractate Kesubos. We pick it up at the bottom of page 21b. Rabbi Abba said that Rav Huna said that Rav said, in the case of 3 judges who convened as a tribunal to ratify a document and a person raised a challenge with regard to the fitness of one of them to serve as a judge, thereby preventing ratification of the document, right? So what we've got here is some kind of a dispute about an underlying obligation, a financial obligation represented by a document. The original document was witnessed, presumably, and the witnesses signed on to the document, and now somebody's bringing that document later. Could be a ketubah, could be a promissory note, and they want to have it ratified, say that this is a legitimate document. Presumably the borrower refuses to pay, or the husband who's now coming out of a divorce, or perhaps the husband died and his heirs, and they don't want to pay. That one way they can attempt to get out of paying their obligation is to say, I don't know anything. There was no ketubah, or there was no loan originally, and this document that you're presenting is a fake document, a false document. Okay, so the lender or the wife is now coming before the court to have that document ratified. In this court, we saw yesterday, one possibility is that the judges will recognize the signatures of the witnesses, and that might be enough. Perhaps they don't. Witnesses are going to come, the witnesses themselves, and say, that's my signature. Perhaps the original witness died, but people who knew him now come and say, I recognize that signature. That is valid. That's going to be the procedure of ratifying this document in a court of law. Well, now here's a different kind of challenge that the one who is seeking to get out of making a payment could make and say, well, these judges are not qualified to pass judgment on this document, right? So in this case, where 3 judges have convened to ratify a document and a person raised a challenge with regard to the fitness of one of those judges, thereby preventing ratification of the document, because you need 3 judges. A court, a beis din, is assumed in the normal case to be a court of 3 or more judges. So if there were 3 and now one of them is disqualified, you've only got 2 judges and they're not going to be able to ratify the document. However, as long as they did not yet sign the ratification, the other 2 judges may testify about the acceptability of the judge whose fitness was challenged, and he then signs the ratification. However, once they signed the ratification, they may no longer testify about his fitness and thereby enable him to sign the ratification. Right? So 2 judges have already signed and said, we witnessed this document, we examined witnesses, it is a valid document, and now they sign the ratification. But before the 3rd judge signs his name to it, somebody comes forward and says, no way, that judge is not fit to be a judge. So now it's too late for the other 2 judges to act as witnesses and say, well, wait a minute, this colleague of ours, we know that he is a reputable, good man, and these witnesses who come to challenge him and challenge his fitness, they're wrong. But if they've already signed the document, they're no longer considered impartial judges. They've got a stake in seeing this ratification finished, and so they will not be allowed to be the ones who testify as to the fitness of the 3rd judge, their colleague. Now, the Gemara elaborates, with regard to a challenge, of what sort was this law stated? If it was a challenge based on an allegation of theft, meaning that the witnesses testified that this 3rd judge is unfit, and that because he stole something, and the judges who testified that he is fit, well, then it would be the judges who know him and say he's fit, that's 2 witnesses, and the 2 new witnesses who come and say, no, that judge is unfit because we know that he stole something, we saw him do it. Well, now you've got a case of 2 witnesses versus 2 witnesses. As a legal matter, you establish that something has happened by the sworn testimony of 2 witnesses. But now you've got conflicting testimony from 2 pairs of witnesses. So what happens? So 2 witnesses come and say that this judge stole and therefore he's unfit to be a judge. But his fellow judges are also 2 witnesses and they say he is fit to be a judge. Well, then what? So the witnesses who testified that he is unfit and the judges who testified that he is fit are 2 witnesses and 2 witnesses who contradict them. And in that case, the allegation of theft is not completely eliminated. We just are not sure. We've got conflicting testimony from 2 valid pairs of witnesses, so that leaves us in an uncertain state. Okay, so what do we do? So if it was a challenge based on an allegation of flawed lineage, for example, that this judge is actually a Canaanite slave and therefore unfit to serve as a judge, that is not establishing the matter, right? When 2 witnesses come and say he is a Canaanite slave and therefore he's unfit to be a judge, that's not considered establishing that he's a Canaanite slave. That's considered revealing the matter. Whether or not he is a Canaanite slave, there's other ways to establish that. We can do further examination and we're going to be able to prove it. So the 2 witnesses who arrive to say, he's a Canaanite slave, that is the difference between revealing and establishing. Very interesting. Because it's already, capable of being proven in many other ways, whether this man is a Canaanite slave or not, we're not actually relying on the witnesses to establish that. They're just coming to alert us to the fact that he is such an unqualified judge because he's a Canaanite slave. That is a mere revealing of a matter that will ultimately be revealed in any case and does not require actual testimony. Therefore, there is no conflict of interest preventing the judges from asserting his fitness after they sign. And the Gemara concludes, actually, I will say to you that it was a challenge based on an allegation of theft. Now, you would think that if 2 witnesses versus 2 witnesses, one says that he stole, the other say he didn't steal, that leaves an aura of uncertainty about that judge, and therefore he should be dismissed as a judge. We can't rely on him since there is this uncertainty about whether he's a moral person or not fit to be a judge. But however, if the 2 fellow judges as as a pair of witnesses say, we know about him that he repented. They're not coming to say, no, he never stole. They're saying, yes, we know he stole, and he completed his repentance. Then that is why he is fit to be a judge. Then he is now fit to be a judge. So in that case, their testimony does not contradict the original testimony that he was guilty of theft, and there is no uncertainty. The two pairs of witnesses agree with each other. Two came and said he stole, and then his fellow judges say, yes, he stole, and then he repented, and that is why he is fit to be a judge. It's very interesting, this idea where the example that's brought about a judge and whether he's fit to be a judge or not, is a serious crime that this man stole something from someone else, and yet the fact that he completed a process of repentance rehabilitates him even to the extent that he could serve as a judge. It's quite different than what we're experiencing these days with cancel culture, right? This idea that if somebody committed some kind of an egregious act, that he is forever canceled or she is forever canceled, actually goes against, our tradition and Jewish law. There are certain crimes that one can never come back from because they're death penalty offenses. Theft is not one of them. And so if this person performed all the steps of the atonement that are necessary, so then he can come back into the good graces of society, as it were, and even serve as a judge. But it's going to require that repentance was complete, was sincere, is provable, and can even be established by the testimony of two fellow judges. Now, Rabbi Zera said, this matter I heard from Rabbi Abba, and if it was not for Rabbi Abba of Akko, I would have forgotten it. With regard to a case of 3 judges who convened as a tribunal to ratify a document and one of them died before signing the ratification, the surviving judges must amend the standard formula of the ratification and write, we were convened in a session of 3 judges, and one of the judges is no longer alive. So in that way, it is clear that although only 2 judges signed the document, there were still 3 judges living and examining the document when they ratified it, right? It was ratified by 3 judges. It's just that the 3rd judge didn't survive to be able to sign it. So this is going to be a valid ratification. Rav Nachman Bar Yitzchak said, and if the judges wrote in the ratification, this document was produced before us, the court, they no longer need to add that they were 3 judges, as when unmodified, the term court connotes a tribunal of 3 judges. And the Gemara asks, well, perhaps it was an impudent court. And that is in accordance with the opinion of Shmuel. As Shmuel said, 2 judges who convened a tribunal and judged, their verdict is a binding verdict. However, because they contravened the rabbinic ordinance mandating that a court must be comprised of 3 judges, they are called an impudent court. Therefore, writing before us, the court, does not rule out the possibility that the document was ratified by fewer than 3 judges. And the Gemara answers, it is clear that the document was ratified by the requisite 3 judges, as it is written in the ratification, before us, the court of our teacher, Rav Ashi, which presumably conforms to the rabbinic protocol. But the Gemara asks, and perhaps the rabbis of the court of Rav Ashi hold in accordance with the opinion of Shmuel, who said that if a court of 2 judges met, it is an impudent court, but their ruling is binding. So it's still called a court, even if it is an impudent court. And then the Gemara will establish, okay, but in that case, they were saying this was a court of Rav Ashi, and that is a significant, description of a court for us to be confident that it was not an impudent court, and it was a court of 3. And that concludes the discussion of Mishnah number 3. Now we go on to Mishnah number 4. We're still on page 22a. Mishnah number 4. With regard to a woman who said, I was a married woman, and now I am a divorcee, she is deemed credible, and she's permitted to remarry. Why wouldn't we believe her? What is the question, the underlying question here? it's that there's no other evidence, right? There's no other witnesses. There's no marriage document or divorce document. So the only evidence we have as to what her state is, whether she's married or not married, is her own testimony. And here we have this same principle that we've seen a few times, right? She says, I was a married woman and now I'm a divorcee. She is deemed credible. Why? Because the mouth that prohibited is the mouth that permitted. Meaning, when she said, I was a married woman, maybe we didn't know that about her. So when she says, I was a married woman, at that point, she's telling us that she was in a state of being prohibited to all the men in the world except her husband, right? The mouth that prohibited was her own. She said, I was married. And so she's now established herself as somebody that is not permitted to go marry anyone else. So she, if we don't know anything about her, then it's by her own testimony that she went from a presumptive status of being a single woman and permitted, to all the eligible men in the world, to being a woman who was married and thus prohibited to all the men in the world other than her husband. Then she continues and say, but I was divorced from him, and that's why I'm now permitted to marry again. So the mouth that prohibited is the mouth that permitted, and this is similar to the evidentiary principle of migo, which says that somebody who tells that in giving testimony they reveal something prejudicial about themselves is going to actually enhance their credibility because they didn't need to say that. Now that they've told us something, that they are the ones who establish something negative about themselves, it must be because they're an honest person, and therefore we're going to believe the next thing that they say. And likewise here, the mouth that prohibited is the mouth that permitted. However, if there are witnesses that she was a married woman, right? So now we establish through the testimony of others that she was once married, and then she says, I'm a divorcee, she is not deemed credible. In other words, the only one who can establish her as being divorced is her own mouth. She doesn't have a divorce document. She doesn't have any other witnesses that say that she was divorced. Other people come here to testify that she was once married. We need more evidence than simply her saying, I'm a divorcee. Similarly, with regard to a woman who said, I was taken captive, but I am pure, as I was not raped while I was in captivity, right? While I was captured by a marauding army. So she is deemed credible, and she's permitted to marry a priest, as the mouth that prohibited and established that she was taken captive is the mouth that permitted and established that she was not defiled. Right? The fact that a woman is raped doesn't mean anything with respect to the vast majority of Jews in the world. Right? It doesn't matter that a woman was raped. She's permitted to marry any Jew except a priest. Right? A Cohen is not permitted to marry a woman that was a divorcee. If he's a high priest, he can't even marry a widow. And tragically, a priest is not permitted to marry a woman, that even if she was raped because she had sex outside of marriage. Not her fault. She remains permitted to every other Jew, but it's just the priest was held to such a high standard that she would be prohibited to him if he was going to continue serving as a priest in the temple. So if she's the one who says, I was taken captive. Now, a woman who is, was captured in ancient times, it was presumed that she was raped. That was just, part of the terrible culture of that time. But if no one knew that she was taken captive, and she's the one who comes and says, I was taken captive, but I was not raped, so we believe her on both counts. However, if there are witnesses who say that she was taken captive, and all she says is, yes, but I was not raped, then she is not deemed credible in the absence of other evidence. And if witnesses came after she married, this woman need not leave her husband. So that's the interesting distinction between evidence that establishes, what is permitted to her ab initio versus after the fact, right? So the one who said, someone comes and says she was taken captive. Now they've established, that she's in a status that she's presumed to have been raped. She says, yes, but I was not raped. Then, she's not permitted to marry the priest. But if before all this happened, she married a priest anyway, and then somebody came and said, yeah, well, you were captive, weren't you? You're not allowed to marry that priest. And she says, yeah, but I was not raped. Now we don't make her leave her husband, the priest. She can stay in the state where she is. And that is a general principle, similar to, possession is 9/10 of the law. Like once a matter is established, the one who comes to, unsettle the status quo, as it were, has the burden of proof, and sometimes a very high burden of proof. If she hasn't married the priest, then her status is, she's not married to a priest, and it's going to be difficult to get her to be permitted to marry the priest if it's established that she had been a captive. But if she's already married to the priest, then the burden, of establishing a status that's going to cause her to leave the priest, again, that is a high burden of proof. That was Mishnah number 4. Here comes the Gemara. Rav Asi said, from where in the Torah do we get this principle? The mouth that prohibited is the mouth that permitted. From where is this derived? Answers the Gemara, it is derived as it is stated, I gave my daughter to this man, la'ish hazeh, as a wife. This is Deuteronomy 22:16. So in Deuteronomy, the 5th book of the Torah, we have a kind of review. The whole book of Deuteronomy is Moses giving his final sermon, as it were, to the children of Israel as they're assembled on the edge of the promised land about to enter. Moses is not going to be allowed to enter the promised land, so Joshua will lead them in. But Moses, the man of few words, who was so tongue-tied that he was afraid he wouldn't be able to speak when he approached Pharaoh, and said, pick someone else when God said, you're going to be my prophet. Now, at the end of his life, is, so attached to the Jewish people, so dedicated to being their teacher, and finally so accustomed to being a public speaker that his final sermon is a month long. But at any rate, he reviews many of the laws that were given in the first 4 books, and among them here at Deuteronomy 22:16 is what happens, kind of related to what we're talking about here, if a father gives his daughter to marry, his new son-in-law, and then the son-in-law comes back and says, well, you told me that this daughter of yours was a virgin, we got married, and on our wedding night I discovered that she's not a virgin. And so now there's going to be a to-do, a scandal, as it were. And, they say, bring the proof, right? So the father is claiming, no, she is a virgin. And the reason that this new husband is coming and saying that she's not is because he doesn't like her for some other reason. And he's, a callous fellow, a real son of a gun, who is actually willing to slander his new wife just to get rid of her, right? What he really wants is out of the marriage, and he's willing to say that this poor girl is not a virgin when she is, and that's the dispute that's going on in that situation in Deuteronomy 22:16. And so we're going to use this verse from the Torah, says the Gemara, to prove this principle: the mouth that prohibited is the mouth that permitted. And how does it work? So I gave my daughter to this man as a wife, and when the father said that he married her off to the man without revealing his identity, he rendered her forbidden to all men. And when he then says, this man, right, the syntax of Hebrew here is, I married her to a man, this, right? So he says he's married her off, so now she's become prohibited to all men, and said this, married her off. I married her off, so now she's prohibited to everyone except who? This new son-in-law of his. And so the mouth that prohibited her to all men is the mouth that permits her to this particular man. The Gemara asks, why do I need to derive this principle from the verse? Actually, the principle is based on logic. He rendered her forbidden, and he rendered her permitted. Rather, where this verse is necessary is in order to derive the law that Rav Huna said that Rav said. As Rav Huna said that Rav said, from where in the Torah is it derived that a father is deemed credible to render his daughter forbidden? It is derived as it is stated, I gave my daughter to the man. And the Gemara asks, why do I need the subsequent term, this, hazeh, the man, ish, hazeh, this, right? Because the this comes after man in Hebrew. And the Gemara explains this is necessary to derive the law that Rabbi Yonah taught. As Rabbi Yonah taught in a Baraisa in the verse, I gave my daughter to this man, written in the context of a husband slandering his wife. This is written to infer the law in this passage The laws in this passage apply to a man who slanders his wife, but not to the yavam, right? The surviving brother of a husband, in the case of levirate marriage. That's not really on topic for us, and so the Gemara keeps moving. The sages taught with regard to the woman who said, I am a married woman, and then said, I am unmarried, that she is deemed credible. Again, the mouth that prohibited is the mouth that permitted. So she says, I'm a married woman, so now she's prohibited to everybody. And then she said, I am unmarried. Okay, and she's going to be credible in this. And the Gemara asks, but didn't she render herself an entity of prohibition when she said she was married? She rendered herself forbidden to all men. How then can she abrogate the prohibition? And Gemara answers that Rav bar Rav Huna said it is referring to a case where she provided a rationale. Right? When she said she was married, she's not saying she was married and then I was divorced. Right? We already examined that case. Here she's saying, I'm a married woman. And then later she says, I'm not a married woman. So if we believe her the first time, then why are we believing her the second time? And if we believe her the second time, aren't we believing somebody who lied the first time? And the answer is yes. And sometimes she provides a rationale for why she lied in the first place that is acceptable. And that's why we believe her when she says she is not married. And where am I? Yes, it is a case where she provided a rationale, a matla, for her initial statement and explained why she said that she was a married woman. And that was also taught in a baraisa with regard to the woman who said, I'm a married woman, and then she said, I am unmarried, that she is not deemed credible. And if she provided a rationale for her initial statement, then she is deemed credible, right? So if she says, I'm married, and then she says, I'm not married, she's contradicting herself, so that's somebody that we would not believe as a witness. Once you establish that a witness has lied, you don't believe anything the witness says. But if she gives a good reason why she lied, then she is believed. And there was an incident involving an important woman who was outstanding in beauty, and many men were clamoring to betroth her. And she said to them, I am already betrothed. And sometime later she arose and betrothed herself to a man. And the sages said to her, what did you see that led you to do this? And she said to them, initially, when unscrupulous people approached me asking to marry me, I said I am betrothed. And now that scrupulous people approached me, I arose and betrothed myself to one of them. And the Gemara notes, this law was raised by Rav Acha Sar Habira before the sages in Usha, the seat of the Sanhedrin, and the sages said, if she provided a rationale for her statement, she is deemed credible. And that's why I titled tonight's show, The Bartender's Wedding Ring, right? Because this is, kind of well known, right? If a woman, especially a very attractive woman, has the kind of job where she's surrounded by men, especially men who are drinking, she just wants to keep them away. And very often waitresses, bartenders will wear a wedding ring just to get these guys off her case. And it's not that she's lying; it's that she has a good reason in that environment to pretend, as it were, that she's married just for the purpose of keeping them away from her. And this is the same practice that this woman in the story in the Talmud was doing. She was being hounded by guys who wanted to marry her and who were unsavory. And so she said, hey, I'm already betrothed to a man, leave me alone. And so then people assumed she was betrothed. And then it turns out she wasn't betrothed and said, well, were you lying then or are you lying now? And she said, no, I was lying then because I was surrounded by unscrupulous men. Now that a proper, appropriate partner for myself to become married to is here, I am betrothed to him. So Shmuel raised a dilemma before Rav. If a woman said to her husband, I am ritually pure, as I am ritually impure, means that I am menstruating, I'm not available for marital relations. And then she says, actually, I am pure. So what is the law? Is she permitted based on her latter statement, or did she render herself an entity of prohibition with her first statement, and therefore she remains forbidden? And Rav said to him, even in that case, if she provided a rationale for her statement, she is deemed credible. And the Gemara relates, Shmuel learned this law from him 40 times to ensure that he would not forget it. And even so, when confronted with a similar situation, Shmuel did not rely on that lenient ruling and did not take action with regard to himself and his wife. For some reason, his wife said to him, listen, I'm in the way of women right now. Okay? He said, so we're not permitted to each other. And then later she said, listen, the reason I said that is because such and such, I had a good reason. So he could have taken advantage of that and say, oh, great, we are permitted to each other. Let's have a date night. But out of sheer piety, now that she said that, he said, you know what, we'll wait till next month. Now we're on page 22b. The sages taught that if two witnesses say the husband died and two witnesses say he did not die, or if two witnesses say this woman was divorced and two witnesses say she was not divorced, this woman may not remarry as there is no unequivocal testimony that she is unmarried. Now, we recall we spent a lot of time talking about this in Tractate Yevamos, this case of the wife who returns from overseas, a wife who's waiting for her husband who went on a journey overseas, and he doesn't come back. And we don't know, is he alive, is he dead? And then only one witness comes and says, I saw your husband and he died. Okay, so now we don't have two witnesses establishing the death, but by rabbinic law, the sages ordained that so this woman won't be stuck waiting for the rest of her life because there may not be another witness. She can take a chance, rely on the testimony of one witness, and get remarried. If the husband then actually turns out to be alive and he comes back, she's going to have to leave the new husband because she relied on one witness. However, if two witnesses come and say that the husband is dead, she's completely free to remarry. And even if it turns out that they were mistaken and the husband comes back, now she doesn't have to leave the second husband. It's just the way that it happened. Or maybe she has to leave the second husband, but she's permitted to the first husband. Whereas if she relied on a single witness, she's going to be prohibited to the new husband and prohibited to the original husband. But if two witnesses come and say the husband died, and then two witnesses contradict them, now she's really got a problem, right? So okay, finally somebody comes and says your husband died, so she's going to be free to remarry. But then, so two witnesses established it. But then two more witnesses come and say, no, he didn't die. So where are we? By two witnesses is a matter established, but we have two pairs of witnesses with contradictory testimony, so we have uncertainty. So then what? So the sages taught, if two witnesses say the husband died, and two witnesses say he did not die, or if two witnesses say this woman was divorced, and two witnesses say she was not divorced, then in both of these cases, she may not remarry, as there is no unequivocal testimony that she is unmarried. That uncertainty means she is not free to remarry. And if she did remarry, she need not leave her new husband, right? So again, that burden of proof problem. If we can't establish with certainty that she's divorced or that she's a widow, she's not free to remarry. But if she went ahead and married anyway, perhaps before this testimony was brought, and now the testimony happens, let's say the second pair of witnesses who say actually she is not divorced or the husband did not die, and in the meantime she already remarried, now she doesn't have to leave that new husband because that is her status, and we're not going to overcome that status with this set of circumstances. Rabbi Menachem Bar Yosei says she must leave her husband. And Rabbi Menachem Bar Yosei said, when do I say that she must leave the second husband? It is in a case where witnesses came to testify that she is still married and she remarried after that, right? So if the two witnesses said your husband died, two witnesses say he didn't die, and in the face of that uncertainty, she went and remarried anyway, then according to this rabbi, she has to leave the second husband. But according to the majority, even in that case, like she was smart and she just went ahead and remarried, and now the court isn't going to step in and force her to undo the second marriage. She shouldn't have done it, but she did, and so they're not going to make her leave the second husband. However, she remarried and the witnesses came thereafter. Even according to Rabbi Menachem, she need not leave the second husband. And the Gemara asks, after all, they are two witnesses testifying that she is married and two witnesses testifying she is not. How then can the ruling be that remarrying, she need not leave her second husband? In that case, the one who engages in intercourse with her stands liable to bring a guilt offering for uncertainty. If she remarried in the face of this uncertainty, the contradictory testimony of two pairs of witnesses, how can we allow her to stay in that second marriage? Since there's uncertainty, the new husband stands to bring a guilt offering, an asham talui, the guilt offering of uncertainty. What is that? When you commit a sin unwittingly, that would result in death at the hands of the heavenly court. If you do it unwittingly, that's when you bring the chatas, the sin offering. If you're not sure whether you committed the sin or not, that's when you become liable to bring the guilt offering of uncertainty. So doesn't that apply in this case? And Rav Sheshes said, this is a case where she married one of her witnesses who testified that she is unmarried. As far as he is concerned, there is no uncertainty. And the Gemara asks, well, she herself stands liable to bring the asham talui, the guilt offering for uncertainty, as she has no independent knowledge whether her husband died. And the Gemara answers, no, actually, this is a case where she says, it is clear to me that he died. There might be two witnesses coming to say that he didn't die, but in her own mind and in her new husband's mind, they are sure, so they're not going to bring the asham talui. She's already married, so we're not going to make her leave the second husband despite the contradictory testimony, since she became permitted to marry with the testimony of two witnesses that her husband had died or that she was divorced. New subject. Rabbi Yochanan said that if two witnesses say the husband died and two witnesses say he did not die, this woman may not remarry. And if she remarried, she need not leave her husband. So if two witnesses say this woman was divorced and two witnesses say she was not divorced, this woman may not remarry. And if she did remarry, she does have to leave her husband. So what is the difference between she's a widow or she's a divorcee? That in the case of contradictory testimony about being a widow and she remarried anyway, she doesn't have to leave the new husband. But in the face of contradictory testimony of whether or not she's a divorcee and she remarried anyway, she does have to leave the new husband, according to Rabbi Yochanan. Why? What's the difference between being a widow and being a divorcee? The Gemara asks, what is the difference? What is different in the first clause of Rabbi Yochanan's statement, where if she remarried, she need not leave her husband? And what is different in the second clause, where if she remarried, she does leave her husband? Divorce versus widowhood. And Abaye said, interpret Rabbi Yochanan's statement in a case where each testimony was given by one witness. If one witness says the husband died, can she remarry? Yes, because the sages allowed the testimony of a single witness to permit a woman to remarry in this case where the husband died while he was a trip overseas. We're not sure if he's dead or not. One witness says he's dead, she can remarry. Now, two witnesses come and say, actually, he's not dead. Very interesting case. Then what? So if one witness says he died, the sages instituted an ordinance and accorded him credibility like that of two witnesses in order to enable his wife to remarry. And that is in accordance with the opinion of Ula. As Ula said, wherever the Torah deemed one witness credible, his legal status there is like that of two witnesses. And the legal status of that second witness who says he did not die, right? So if one witness says the husband died, she's permitted to remarry. If a single witness comes and says, actually, he did not die, for sure, that's meaningless, right? A witness coming to say your husband did not die has said nothing at all, because it's only to establish that a husband did die that we accept the testimony of one witness. The testimony of two witnesses is required to establish that actually he did not die. And since only one witness came to say that, we set aside that second testimony of the single witness, and she's for sure permitted to remarry and to stay remarried. And the Gemara asks, well, if so, that this is a case of the testimony of two witnesses against the testimony of one witness, it should be permitted for her to remarry even ab initio. And the Gemara answers that she may not remarry ab initio due to the opinion of Rav Asi. As Rav Asi said, that in any case of uncertainty, the verse, remove from you a crooked mouth and perverse lips put far from you, Proverbs 4:24, applies. Although it is not a strictly prohibited action, it is nevertheless inappropriate to remarry in the face of uncertainty. In the latter clause of Rabbi Yochanan's statement, where one witness says this woman was divorced and one witness says she was not divorced, both of them are testifying that she was a married woman, and that witness who says she was divorced is one witness. So two witnesses came. One says she was married and divorced. The other one says she was married and not divorced. So two witnesses have testified that she was married. 2 witnesses have established that she is prohibited to remarry. Only one of them is saying, and she's divorced. So you can see why, if that's the case, that there was only a single witness for each matter, that we've established for sure that she was once married, and we have not established that she's divorced, and that's why she's prohibited to remarry in that situation. I'm almost done. If you got questions or comments, get them in. Rava explained the difference between the 2 cases in Rabbi Yochanan's statement and said, actually, it is a case where they are 2 witnesses testifying that she is married, and 2 witnesses testifying that she is not. And so we're not going to change the facts and say actually it was only 1 witness on each side. No, it was a case of 2 witnesses contradicting 2 witnesses. But what really happened? It was 2 witnesses testifying that she is married and 2 witnesses testifying that she is not. And Rabbi Yochanan saw the statement of Rabbi Menachem Bar Yosei as correct in the case of divorce, but did not see it as correct in the case of death. What is the reason that Rabbi Yochanan distinguishes between the 2 cases? Why does he come out with a different result if 2 witnesses say she was married and widowed, so she can remarry, versus when 2 witnesses say that she was married and 2 witnesses say she was divorced, she cannot remarry? What's the difference? What is the difference? In the case of death, if ultimately her husband returns alive, she's unable to deny that he is alive, right? So, it's a very clear-cut case. She says he's dead, then he shows up. Okay, well, there's no lying in that situation. Now we've got the full proof. Therefore, the woman's decision to remarry is credible, as if she were not certain that he was dead, she would not have remarried. However, in the case of divorce, even if her husband returns and claims that he did not divorce her, she could stand up and lie. She could deny his claim. They could still have an argument. There's no argument if she said he's dead and then he shows up. But if she said they're divorced and he comes and says we're not divorced, the argument continues. It's a different case. The Gemara asks, and is the woman impudent to that extent that she would lie in the presence of her husband and claim that he divorced her when he didn't? But didn't Rav Hamnuna say with regard to a woman who said to her husband, you divorced me, and he says he didn't, she is deemed credible, as there is a presumption that a woman is not insolent in the presence of her husband. And the Gemara answers, this statement that she is not insolent applies only in a case where there are no witnesses who are supporting her. However, in a case where there are witnesses who support her, she would certainly be insolent. If she's got somebody else to back her up and say she's divorced, she might lie because she's got the backup. What's interesting about that is, well, if she's got witnesses, plural, to say that she's divorced, then what? We don't even need her testimony. We can rely on those witnesses. But that's beside the point. Rav Asi explained the difference between the 2 cases in Rabbi Yochanan's statement and said that it is a case where the witnesses say he died now or he divorced her now. With regard to the husband's death, there's no way to immediately clarify whether or not he is dead. With regard to divorce, there is a way to immediately clarify whether or not he divorced her, as we say to the woman, if it is so, that this is what happened, that you are divorced, show us your bill of divorce. Since the testimony was that the divorce was now, that very recent, it is not feasible that she lost the bill of divorce. If she fails to produce the bill of divorce, the witnesses that testify that she is divorced are apparently false witnesses, and therefore, even if she remarried, she must leave her husband, right? They're drawing that distinction. Why? In the face of contradictory testimony, if their contradiction is whether or not she's a widow, we allow her to remarry. But if the contradiction is whether or not she's a divorcee, we say, don't remarry. We're going to need more evidence to establish that you are permitted to remarry. Okay, that's what we've got today. Let's see questions or comments on Kesubos 22. Nina says, I'm sorry, there aren't any questions or comments. Okay, so that's what we've got for today. With God's help, we'll be together again tomorrow, the regular Friday time, which is noon Pacific for page 23 here in